Namaskar and welcome back. Last time we covered what runs after your appeal is filed. Today we walk into the hearing room itself. Can GSTAT actually summon someone and put them under oath like a civil court? And once the tribunal decides your invoice is genuine or your ITC was rightly claimed, is that decided for good? Here's the twist. Once GSTAT records a finding of fact, higher courts almost never touch it again. That single rule changes how you should prepare for this stage. Let's go inside. Every GSTAT proceeding rests on one idea. Higher courts decide law, GSTAT decides facts. Under Section 111, the tribunal isn't bound by the Code of Civil Procedure at all. It's guided instead by natural justice, free to regulate its own hearings. That's deliberate. It lets GSTAT move faster than an ordinary court while staying fair. But it also means this is the one stage where your facts get properly tested. Get it wrong here, and there's very little room to fix it later. So, how does a hearing run? The case is called, appearances recorded, and the bench identifies what's genuinely in dispute. The appellant argues first, the department replies, and a short rejoinder may follow. Then the bench's own questions, often where cases are actually won or lost, since members probe the facts directly. Arguments closed, the order is reserved, then pronounced. Adjournments exist, but they're rationed. Sufficient cause only, capped at 3 per party for the whole appeal. Ask for a fourth, and you're arguing against your own credibility. Here's what sets GSTAT apart from an ordinary appellate desk. Section 111 gives it nearly every power a civil court has while trying a suit. Summon a person and examine them on oath. Order discovery of documents like bank statements, e-way bills, transport records, portal data, take evidence by affidavit, and under Rule 46, order cross-examination by video conferencing if needed. It can call for government records, customs, DGFT, the department's own files, short of anything legally privileged, and issue a commission to examine a witness or inspect a site itself. This isn't paperwork review, it's real fact-finding. Which brings us to the most important idea in this module. GSTAT decides whether an invoice is genuine, whether ITC was rightly claimed, how a supply is classified and valued, whether an e-way bill gap was innocent or deliberate. Once the tribunal records that finding, it's treated as settled. A high court steps in only on a substantial question of law, not a technicality, but because the court isn't built to reweigh your evidence. Unless a finding is perverse, unsupported by any evidence, it stands. Courts have applied this to tax tribunals for decades, which is why practitioners call GSTAT the last real trial of your facts. All of this rests on two old principles. Audi alteram partem. No one is condemned unheard. Every party gets notice, a hearing, and a real chance to answer the other side's evidence. And nemo judex in causa sua, no one judges their own cause. The rules actually codify this, requiring a member to recuse if they've had a personal or professional relationship with the party or were involved earlier in any other capacity. Skip either principle and the order doesn't survive, whatever the correct tax position was. Once arguments end, the order is reserved, and under the rules, it should be pronounced within about 30 days of the final hearing, excluding vacations. It must be written, dated, signed by every member, and it has to be a speaking order, one that states the facts, the issues, both sides' submissions, the reasoning, and a clear operative direction. A bare appeal dismissed invites a remand on its own. And if members genuinely split, the president brings in another member to break the tie. The disagreement gets decided, never left hanging. What can that order say? Allow the appeal, and the order below falls entirely. Dismiss it, and the original stands. Partly allow it, ITC upheld, penalty reduced, say. Modify the tax, interest, or penalty directly. Remand the matter where facts genuinely need re-examining. Or pass a rectification order, fixing a clerical slip, not reopening the merits. Genuine catch. The Act gives 3 months to flag such an error, but the tribunal's own rules ask for the actual application within 1 month. Don't sit on it. So you disagree with the order, where do you go? A state or area bench order goes to your jurisdictional high court only on a substantial question of law within 180 days. Courts apply a settled test from the Supreme Court Chanilal Mehta ruling. Does it affect real rights? Is it genuinely unsettled? Does it matter beyond this one case? But a principal bench order skips the High Court entirely, straight to the Supreme Court. Every principal bench order, not just the headline place of supply disputes. It's not the subject matter, it's which bench decided it. So, before the hearing, put everything on record at the GSTAT stage. Additional evidence is the exception, not a second chance. Build a proper indexed paper book. The bench reads fast and wants your document in seconds, not minutes. Keep oral arguments on the real issues, not a rereading of your written submissions. Members ask factual questions directly, so know your own file cold. And separate deliberately fact from legal argument. That distinction decides whether your next forum is even open to you. 3 things to carry forward. 1. GSTAT has real civil court powers, summoning, oath, discovery, commissions, and builds an actual factual record, not just reviews a file. 2. That record becomes almost final. Only a substantial question of law gets you into a high court, and only a principal bench order goes straight to the Supreme Court. 3. A properly reasoned speaking order pronounced within the rule's own timeline is what makes it hold up on appeal. Anything less invites a remand. The GST Appellate Tribunal is far more than another box to tick. It's the stage where your facts are actually tested, and a well-prepared hearing here can decide the future of your entire dispute. We've now walked the full journey, from what GSTAT is, to filing, to the hearing itself. Next time, the practical mistakes that sink even a legally strong GSTAT case, and how to avoid everyone. If this helped you see the tribunal differently, hit like, subscribe, and I'll see you there.